We'll call the meeting to order. That's the Committee of Adjustment meeting of January 9th, 2024. It's 2:00 p.m. We have a quorum. The committee has a quorum. I'll read the territorial land acknowledgement. The Township of Hamilton is situated within the traditional territory of the Mississauga, Anishinaabe, and Chippewa nations, collectively known as the Williams Treaties First Nations. Our work on these lands respectfully acknowledges their resilience and their longstanding contributions to the area now known as the Township of Hamilton. This is a Committee of Adjustment meeting. Before I explain the process, I'm going to ask for an amendment to the agenda to reflect the election of a chairperson for the committee. It's a new year, so we need to re-elect the Committee of Adjustment chairperson. So I will open it up to nominations from the committee. Okay, so member Larry Williams is nominating Scott Jibb to be the chairperson. Is there a seconder? Mark is seconding that. Any questions, comments, anything else? All in favor? Carried. Okay, Scott, do you want to take this forward and elect a vice chair?
I will. Staying with the modified agenda, I would like to entertain a motion for position of vice chair for the 2024 year. John?
Nominate Margaret Lushin as vice chair.
Thank you. Do we have a seconder to that? Second by Bruce. Any further nominations? Seeing none, all those in favor of the nomination? Carried. Thank you. Item 5 on our agenda is the declaration of procuring interest. Is there anything to be declared today? Seeing none, that shall be recorded. Item 6, approval of minutes of previous meeting. We do have a prepared motion that the minutes of the Committee of Adjustment meeting held on December 12th, 2023 be approved. Could I have a mover and a seconder, please? Moved by Bruce, second by John. Any questions or comments? All those in favor of the motion? Carried. Thank you. I see no business arising from the previous minutes. So we'll move on to item 8 on our agenda, and that is new business. And we do have a minor variance application today, and it is minor variance 2024-01 in the Lloyd name. Could I turn to you, please, Jennifer, for your planning report?
Certainly, through you, Chairman Jibb. I'll just outline the process that we go through when we're considering an application here and at the meeting. I'll provide a summary of my report that was available online. The floor will be opened to the public to make comments. We'll ask that the order of speaking is as follows: those in support of the application, those in opposition to the application, those persons seeking clarification, and then finally the applicant. All persons wishing to speak to the application must address their comments to the chair, and we advise that before speaking, you must clearly and slowly state your name and address so that we can ensure the record is complete. Members of the committee may make comments or ask questions, and the committee may make a decision on the application today, including reasons for the decision and impact public input would have. Those persons requesting a copy of the notice of decision must do so in writing to the Secretary Treasurer or sign the file sheet in the lobby. Be sure that you're signing the correct file sheet. Well, we only have one application today, so there's only one file sheet. And today we are considering an application for a minor variance, A0723. The variance applies to a parcel of land located in lot 23, concession 8. It's in Bewdley, and the property has frontage on Lee's Court. The applicant is applying for 4 variants, which if granted, would permit the construction of a single detached dwelling on an existing lot of record which does not have frontage on a year-round municipally maintained road. The subject property was created by Severance in 1976, and it was part of a negotiation between the landowner at that time and the township, who wanted to acquire Lake Street, which was at that time just a private road leading to the Vincent Massey Memorial Center. The subject property has frontage on Lee's Court, which was constructed as part of a plan of subdivision. It's called the Dennis subdivision. The road has been constructed, including a base coat of asphalt. However, the final lift of asphalt has not been applied. There have been discussions with the developer of the subdivision, and I believe that the final lift of asphalt will be applied in the spring. Under the terms of the subdivision, the developer is responsible for the maintenance and upkeep of the road until a certificate of assumption has been issued by the township. And a certificate of assumption is not issued until a certificate of completion has been issued. The certificate of completion is issued once the works have been completed and reviewed by the municipal engineer. Once the certificate of completion has been issued, there's a 2-year maintenance period before a certificate of assumption is issued. The subdivision agreement applies to all lands within the subdivision, and the subject property was not part of the subdivision lands. The subdivision lands included lands further to the north and the entire street that's known as Lee's Court. Neither, as I mentioned, neither a certificate of completion nor a certificate of assumption have been issued for Lee's Court. The road remains an unassumed road at this time. I provided a key map that illustrated the location of the subject property. I will note that the applicant provided a planning justification letter, which was attached to my report for the committee's consideration. The property is approximately 0.22 hectares located in Bewdley. It's a designated settlement area on the western shore of Rice Lake. As I mentioned, the property fronts on Lee's Court, an unassumed subdivision road. Surrounding land uses are predominantly developed and undeveloped residential properties. The Bewdley Community Center is located immediately to the east of the subject property. County Road 28, which is the municipal boundary, is located about 225 meters to the west. The subject property is located in a rural settlement area. It's located on the Oak Ridges Moraine. The official plan and the provincial policy statement all permit residential development in settlement areas. However, they require properties to have frontage on a year-round municipally maintained road. And at this point in time, the property does not have frontage on a year-round municipally maintained road. Lee's Court is an unassumed road. Once the road has been assumed by the municipality, it will be a public road and development would be permitted, and it would be consistent with the PPS, the provincial policy statement policies. But at this time, since Lee's Court has not been assumed by the municipality, development of that property is premature. There are no natural heritage or natural hazard features identified on the subject property. As I mentioned, the property is located, the entire Bewdley area is located on the Oak Ridges Moraine, and it's designated Rural Settlement Area Oak Ridges Moraine in the township's official plan. It's also located within a landform conservation area category 1, which contains certain limitations on development, intending to limit the site disturbance. It's also identified as an area of high aquifer vulnerability, and there are certain uses that are prohibited, such as generation and storage of hazardous wastes and that sort of thing, none of which is proposed for the subject property. The property is zoned for residential use. Section 18.6 of the Oak Ridges Marine Conservation Plan permits the use or erection of a location of a building or structure, provided that use, erection, and location would have been permitted by the applicable zoning bylaw on November 15th, 2001. At this time, the proposed development does not have frontage on a road, so it doesn't conform to those policies. The Northumberland County official plan. Northumberland County designates the property as rural settlement area. And Northumberland County planning staff commented, when reviewing applications for development proposals in rural settlement areas, policy C1-3 of the county OP required development proposal to promote the efficient use of existing and planned infrastructure and public services. Even though the development proposes to facilitate the construction of a new detached dwelling within the township, it is our understanding that this application has not demonstrated how vehicular and pedestrian access can be legally obtained to the subject property, since Lee's Court is currently considered, they've called it a private road, but it's an unassumed road by the township. Until such time, the proposed variances do not meet the intent of the county's OP, since the property doesn't have access to an open and maintained municipal road. In the Hamilton Township official plan, the property again is designated rural settlement area, and the official plan contains a definition. First of all, section 11.1 states that all new development shall have frontage on and direct access to an improved public road, which is maintained year-round by the municipality or other public authority and has sufficient capacity to accommodate traffic generated by new development. And development is defined as the creation of a new lot, a change in land use, or the construction of buildings and structures requiring approval under the Planning Act. And this minor variance is an application under the Planning Act, and development of this property requires a minor variance. And because it requires a minor variance, it doesn't maintain the intent of the official plan because it doesn't have frontage on a year-round municipally maintained road. So the Planning Act and the Hamilton Township official plan can set out the 4 tests for evaluating a minor variance application. The application must be minor. The application must be desirable for the appropriate use or development of the land. The variance must maintain the general intent and purpose of the zoning bylaw, and the variance must maintain the general intent of the official plan. I'll discuss tests 1 and 3 a little bit later, but with respect to maintaining the general intent of the official plan, the intent is not maintained because the lot does not have frontage on a year-round municipally maintained road, and development is defined as any construction requiring a Planning Act application. And this development of a single detached dwelling on this property requires a minor variance or a zoning bylaw amendment. And as such, it's not consistent with the policies, and it doesn't maintain the policies of the official plan. The property is zoned urban residential first density on Schedule A to the township's official plan. The urban residential first density zone permits a single detached dwelling. The applicant is applying for relief from 4 sections of the official plan. Section 526, 527, 529, and 13.3.1. Section 5.6 of the official plan basically says that, 5.26 of the zoning bylaw says that you have to have, a property has to have frontage on a year-round municipally maintained road in order to be eligible for construction. And that this property does not have that. Section 5.27 states that no person shall erect any building or structure on a lot with frontage on a private road unless the lot is zoned limited service residential. So the limited service residential zone is a zone that's applied to predominantly those lots along the Rice Lake shore where there's private roads and they have frontage on those private roads. So 5.7 allows for construction on a private road where the lots are zoned limited service residential. This lot is not zoned limited service residential. And the limited residential zone, when you're reviewing an application in a limited service residential zone, it speaks to a seasonal dwelling, not a year-round occupied dwelling. So again, Lee's Court is unassumed, and the property, it's not a private road with a property zoned limited service residential. So section 5.29 of the zoning bylaw says development on an unassumed public road may be permitted in accordance with the applicable zone and general provisions of this bylaw. And this section applies to cases generally where we have subdivision developments that you've initiated development of the subdivision, the residential properties are subject to the terms of the subdivision agreement. It's quite common, as it is evidenced in this subdivision. There are, I believe, 4 active building permits within the subdivision, and those lots were allowed to be developed on an unassumed road because the developer had entered into a subdivision agreement agreeing to certain parameters. And that subdivision agreement has been registered on the 6 lots within the Lees Court subdivision. That same subdivision agreement has not been registered upon the subject property in this case. So section 13.3.1 of the zoning bylaw requires a minimum of 45.76 meters for privately serviced lots in the urban residential first density zone. The subject property has 20.12 meters of frontage, and the applicant has requested a variance to temporarily recognize 0 meters of frontage. Now, the lot is deficient in lot area and lot frontage, but the zoning bylaw does contain a provision that allows for the development of a undersized lot in the municipality, provided that you comply with all of the other provisions of the bylaw, because there are lots of existing undersized lots that can be developed in our municipality. We wouldn't necessarily create them now, but they were created in the past, and provided they can do all the services and meet their setbacks, then development is permitted. But in this case, it's not the fact that it's undersized that's a problem. It's the fact that it doesn't have the required frontage on a year-round municipally maintained road. So the applicant has requested basically an elimination of the requirement to have frontage on a year-round municipally maintained road, not a reduction in the requirements. So the requested variances do not maintain the intent of the township zoning bylaw, nor are they minor in nature. The application was submitted as required, or application was circulated as required under the Planning Act. Ganaraska Region Conservation Authority commented that there are no GRCA regulated areas on the property. They had no objection. Hamilton Township Building Department commented that the building department does not support this application. The zoning bylaw specifically prohibits construction on this lot, as Lees Court has not been assumed by the municipality and the property does not form part of the subdivision agreement. The Township of Hamilton Public Works Department agrees with and supports the recommendations of this report, that the application be denied because Lees Court has not been assumed by the municipality, and the maintenance and construction of the road are currently the responsibility of the subdivision developer. Northumberland County Waste Operations commented that residents on Lees Court are required to place all waste materials at the end of Lees Court until the road has been uploaded. That means assumed by the municipality. And they further commented Miller Waste, the curbside collection contractor, has been advised not to access Lees Court for liability issues, as the developer would not agree to an indemnity agreement until the roadway is uploaded to the municipality. They further commented that Waste Miller has no issues traveling this road once uploaded. Northumberland County Planning commented, until the applicant can demonstrate how the subject property can obtain frontage and/or legal vehicular and pedestrian access onto an opened and maintained municipal road to the satisfaction of the township and the county, based on the foregoing, county planning does not support this minor variance application. The application was circulated to all registered landowners within 60 meters of the property on December 20th, and a sign was posted on the property on or before December 29th. At the time I wrote the report, no public comments had been received. However, I did receive an email this morning and they asked that I read this to the committee. To Township of Hamilton, Committee of Adjustment, Minor Variance Application AO 723. My name is Lori Lynn Legere, previously Lang. My address is 7032 Lake Street, Lot 100, Bewdley, Ontario, KOL 1EO. I received notice in the mail regarding a minor variance application AO 723 submitted by Melissa Lloyd for RCP 427, part of Lot 3, Registered Plan 39R 720, Part 1, Lot 35, Concession 8. As a resident of Bewdley, I wanted to express my support for this application. As an abutting neighbor to Lees Court, the intent to continue residential development in the township of Hamilton and this desired development in Bewdley, specifically on Lees Court, is appealing and beneficial to surrounding neighbors and the town. Approving this will support the intended use of this land as it is zoned residential, will help in completing the aesthetic of Lees Court, as well as increase the value of surrounding residents' properties due to the completion of the development on Lees Court. I would appreciate it if my support for this application would be reviewed with the Committee of Adjustment members at Committee of Adjustment meeting on January 9th, 2004. If you have any questions, please feel free to contact me, Lori Lynn Legere. And that was the only public comment that I had received to date. So in reviewing the 4 tests for a minor variance, it is my position that the requested variances are not minor, as they would eliminate the requirement for frontage on a year-round municipally maintained road. Eliminating a zoning provision is not minor, nor is it a variance. The variance is not desirable and appropriate for the land. The requested variance would allow for premature construction of a dwelling on a property that does not have frontage on a year-round municipally maintained road. Such construction could result in damage to a road owned by a third party who is also responsible for the maintenance of that road. The general intent of the township official plan has not been maintained. The requested variances do not maintain the intent of the township official plan, which requires that development occur on a year-round municipally maintained road. The requested variances do not maintain the general intent of the Hamilton Township zoning bylaw 2001-58, which requires lot to have frontage on a year-round municipally maintained road in order to be eligible for a residential building permit. Frontage on a year-round maintained road is required to ensure access to the property. Lees Court has not been assumed by the municipality, and a third party is required to maintain the road and repair it if necessary. Providing access to this unassumed road will pose liability issues. Currently, Lees Court is only being constructed with base coat of asphalt. The subdivision developer has requested permission from the township to apply the top coat of asphalt and then apply for the certificate of completion. Once the certificate of completion has been issued, there's a 2-year maintenance period, after which the municipal engineer will undertake an inspection of the road and ensure everything is fine. And if it is, a certificate of assumption will be issued for the road, and the municipality will assume the road. After the road has been assumed, the property will be eligible for a building permit, as it will have access on a year-round municipally maintained road. So the recommendation is that the application be denied because it doesn't meet the 4 tests for a minor variance. I know that's a lot to take in, so if you have any questions.
We'll just give a moment here to transition our applicant, and I believe there's a solicitor with them as well, with her as well.
Good afternoon, members of committee. Can you hear me?
Yes, we can. Just and welcome. I'll just go through a little bit of process here, and we'll certainly be providing you an opportunity to speak to the application. But I'll simply go, and I don't believe we're going to get any answers here. But is there anyone either with us or on Zoom that is in support of the application above and beyond our applicant and agent? Seeing none, obviously we'll go that there's no one here or present on Zoom in opposition to the application. And I assume also there's anyone present seeking clarification on the application. And I'm seeing none to all of those 3 components. So, sir, I'll come back to you and the floor is yours. I'm assuming that you would like to make a presentation to the committee and of course, our applicant is more than welcome to speak as well. So, sir, please, the floor is yours.
Thank you very much, Mr. Chair. And it's my understanding that the applicant will be relying on the submissions that I make on her behalf. So good afternoon to Mr. Chair and members of the Committee of Adjustment. I am the lawyer for Melissa Lloyd, and I am appearing on her behalf to make submissions with respect to the requested minor variances associated with application A-0723. I'm here today to request that the committee approve the requested minor variance application. While I think staff have done an admirable job in wrestling with the difficult issues that are contained in the report, I have to respectfully disagree with the position taken on this matter, as it is truly unique. And I think it requires careful reconsideration of the staff recommendation based on the submissions and information I will provide you through the course of the next few minutes of my presentation. And I want to take a moment to explain why this is a unique situation that is not covered off by the usual circumstances that are intended to be covered by the policies and zoning bylaw provisions that we are seeking relief from. This is exactly the kind of circumstances that is supposed to be addressed by the minor variance test and provisions. It is exactly why Section 45 of the Planning Act was introduced and into the legislation, to ensure that relief can be obtained in these kinds of unusual and unique circumstances. And so I want to take a moment to address a few key facts that are very relevant and make this and sort of make the foundation for why this application is indeed so unique. So first off, one of the things that hasn't been made entirely clear is that the road is owned by the township. It is not owned. There's some suggestion that the developer owns the road, and that's not in fact the case. The ownership is in the township. All that the owner has is the right to construct on that road, but they have no interest in the actual land or the road. In fact, they just have a maintenance obligation that is established by contract. And so it's incorrect in the circumstances to suggest that the developer owns the road. Secondly, the lot is now on a year-round maintained road. It's not maintained by the municipality directly, but the road is being maintained in accordance with the obligations under a plan of subdivision. And in fact, if anything were to happen to this developer, the township would be left with the obligation of having to finish it and with sufficient securities under the subdivision agreement to do it. And so while the developer is obligated to finish the road under the terms of the subdivision agreement, the township has securities to complete the works. And the township would be obligated to complete the works for those residents that have already taken occupancy of the building, especially, for instance, if the developer went bankrupt. The lot was created, and that is the subject of this application. The lot that was created and is the subject of this application was intended for development on a residential lot and could have been developed up until the time these road prohibitions came in. Critically, the applicant's lot is located between the subdivision and the road that the owners of the subdivision and non-owners are using to access the property. And I want to really drive home the point, and if I can, am I able to share my screen? Is share screen permitted to be given to me?
I'm getting a no from our technical people in the room.
Okay, that's okay. I appreciate that. There are already, one of the things that didn't get put up on this screen is that in addition to the 6 lots that the developer is developing, and at least 3 of which are already occupied, as I understand, but there are also 4 other lots on this road that are using this road to access their properties. And so it is important to understand that we are not changing an existing condition in the township, which again makes this a very unique set of circumstance. Really, all it is adding one more house to an existing condition. And that is already so together with the occupants on the existing plan of subdivision plus the 4 owners using the road already to access dwelling units, we've got a fairly complete subdivision already here. There is no increased liability to the township because of the existence of the subdivision agreement. That it is unfortunate that this comment has been made because it's not entirely accurate. Right now, the road is being used currently by not only residents who occupy the units, but in addition, occupy units within the plan of subdivision, but 4 additional residential houses. And finally, to address the issue that the county has raised, it's factually inaccurate to suggest that our client does not have legal access. We have a legally registered easement across this property, which was provided at the time the lot was created. And so there is, in fact, legal access, and that entirely addresses the county's concerns, save and except for the issue of it being accessed on a municipally maintained road. So with these facts, they mean that the usual policies that would apply do not actually apply. And with that background, I want to turn to my client's submissions on the 4 tests that are applicable, because for the rest of the submissions that were made on facts, I don't think that there's much dispute in terms of what otherwise exists here. But I thought it was really important to clarify those sort of eight points. So first and foremost, the committee needs to consider whether the request is minor. And I submit that this is the quintessential circumstance contemplated by a minor variance. And really, it's as minor as it can really be. All that we are asking to have happen is to be deemed to be included as part of a plan of subdivision that this council has, that the council for the township has already approved. No further work is required to happen. The council's right to the road, or the township's right to the road, exists. They own it. This is very unusual in and of itself. And the township has securities to finish the road. I say it's unusual because in most cases where plans of subdivision are developed, the underlying road asset is not owned by the municipality until it actually assumes the road. In this case, it's unique, and because the township owns the road and has already secured the ability to finish it with secured funds. The circumstance simply could not have been predicted, but when the prohibition was introduced in the zoning bylaw, as in almost every circumstance where plans of subdivision are addressed, they would either require the developer to address existing access, which council did not do, or the municipality would not own the road, as I already mentioned. And that's not the case here. So without the need for major work or any step required to make this lot actionable on a road that is already maintained by an agreement subject to securities, this really is as minor as it gets. And so I suggest, in answer to the first question, the requested variance is to permit really the building of a house 2 years prior to the time at which it will automatically, as of right, be able to do it under the zoning bylaw is indeed minor. Second is the question of desirability and whether it's appropriate for the development of the land. Right now, the only situation that exists when you turn the submissions that you've already heard from township staff on their head is really a major unfairness imposed by the township's decision, where it has allowed some, but not all of the land located on its municipal asset, municipal road, to be developed. This approach is not desirable. Council, in its approach, should treat its residents equally, and to do so, it would allow someone to develop their lands at the same time others on the same road are developing. And one of the questions that oftentimes gets asked is whether this kind of a decision imposes a hardship on somebody, and that it can lead to a decision that it is in fact desirable. In this case, the hardship that's imposed is that one lot owner on the entirety of the lot is forced to wait 2 years while the rest of the lands around them develop, and that is really a hardship. In terms of desirability, a second and critical point is that we are facing a massive housing shortage in Ontario. It is well known and well publicized and documented. You have here a ready lot that can be immediately developed to assist in an incremental way to develop some of the lands in the municipality at the same time as the others are, bringing additional housing and tax revenues to the township. And so from that perspective, for those points, I would suggest to you that this meets the test for desirability, and it is appropriate use for the development of this land. Looking towards whether the general intent of the township official plan is maintained, I suggest to you that specifically the requirement that development occur on a year-round maintained road is in fact maintained because the developer is in the neighborhood, has been contracted by the municipality to maintain the road, and is therefore also permitted as part of its obligation to develop its lots. If this didn't maintain the intent of the township official plan, you could never develop a plan of subdivision, because a plan of subdivision is not on a municipally maintained year-round road until the roads are assumed. What we see is the general intent, and not the specific intent, but the general intent of the official plan is to ensure that people don't develop lots in a municipality that have the effect of forcing a municipality to take over a road asset that it was not otherwise intending to take over. That's not what's happening here. All that we're asking for is some relief from the 2-year prohibition, essentially, that will exist in developing this land. And so because the township has, again, secured the maintenance of its own road by contract, the road is in fact maintained, and the intent of the plan is maintained, which is the critical portion of the test. We don't need to show specific compliance, because otherwise you wouldn't need a minor variance. You have to look at what the intent of the provision is and ask yourself, does it still continue to be maintained? And because we have a plan of subdivision that is located together with our client's lands on the same road that the developer is developing, the general intent of the official plan is maintained. Finally, I'll turn and conclude with my submissions on whether the intent of the zoning bylaw is met. Here you have a case where the purpose of the zoning bylaw is to stop development until the township has at least secured the construction of the roadway by a subdivision agreement. The intent can't be any more, because otherwise, again, same with the official plan provision, you could never develop if the requirement was that you had a municipally maintained road. Rather, you have to have a subdivision agreement in place, which exists here. And while our client's lot isn't a party to that agreement, they are on the very road that is part of that agreement. So it is such a minor distinction to draw in these circumstances. So even if it is not already assumed, the finishing of the road has been secured. As such, the intent of the zoning bylaw has been achieved, namely that the road access has not only been contracted to be built, but the ultimate construction costs have been secured by the township. Equally important is the fact that the bylaw allows development in a limited service residential zone as per 5.27, section 5.27 of the bylaw, which staff already took you to. The reason why I want to emphasize this provision is that provision identifies a condition which the township imposes in those circumstances, which is that as long as the township is not responsible for services and maintenance of the road until it assumes it, and the owner signs an acknowledgement to that effect, then they're allowed to develop on a private road. I appreciate this is not in a limited service residential zone, but because that sort of helps understand and flesh out the intent of the zoning bylaw, perhaps the committee would choose to impose a condition that the applicant acknowledge as part of its application that if the variances are granted, the township is not responsible for maintaining the road. That would entirely address any niggling concern that exists with respect to liability that has been highlighted. And while I don't think any liability exists at law, and I would be happy, I provide that submission to you, that would also address that by having that acknowledgement made in its entirety. The last comment I would make is the suggestion that the reduction to 0 meters of frontage is not a minor variance under 13.3.1. That is really a super technical issue because that is simply tied directly to the question of the road being located on a municipally maintained road. And so the variance that's been identified is to reduce the requirement to 0 meters in order to accommodate that requirement. And so it's not really a variance for the reasons I've already provided, meaning that it's already located on a road that will become public. It's just that it requires a temporary relief from that provision. So based on the foregoing submissions, I respectfully request that the committee approve the requested minor variances, and I'm happy to answer any questions that the committee might have of me at this time.
Thank you. Would our planning staff like to provide a response to some of these components? One for me in particular is going to be that we own the road.
Okay, so yes, I would be happy to address this. There's nothing unique about this subdivision. When a subdivision undergoes subdivision approval, final approval, first it gets draft plan approval. They do all the detailed engineering. They enter into a subdivision agreement. As part of the subdivision agreement, there's usually a schedule in the back of the subdivision agreement that says lands to be conveyed to the municipality. The lands to be conveyed to the municipality are typically the subdivision road lands. So in any subdivision that I have dealt with over the past many years, the lands are conveyed to the municipality upon registration of the M plan, which is the plan that lays out the lots for the subdivision. So in this case, it would have been the 6 lots plus the subdivision roads. The subdivision roads are conveyed to the municipality at that point in time. Now, it's important that it's a kind of a unique thing for all subdivisions, I guess we'll say, because basically they give us the road allowance. So they give us the road allowance lands, and then we give them permission in a subdivision agreement to build the road on those subdivision lands. But we do not own the road until such time. We own the lands on which the road has been constructed, but we don't own the road until the road has been assumed by the municipality. So yes, we own the land on which the road is located, but we have not yet assumed ownership of the actual road surface. And that's the way that any subdivision that I've worked on over the past has been undertaken. And I'll just try to, so that's the one issue. There was reference to 8 lots that front on the road. There were 4 pre-existing lots that were developed prior to the subdivision being approved. There was a private road that went in there. It was private, I think it was a seasonal road. It went in and it serviced a number of lots. And those are already developed lots. They're not undeveloped lots. So there's a little bit of a difference between providing access to a developed lot and providing access to an undeveloped lot, because when you're providing access to an undeveloped lot, you've got your excavators, your bulldozers, your heavy equipment and everything else coming into it that are coming in and out to construct a dwelling on the property. And there's more potential for damage to the road to occur during that construction. That's not to say that somebody may decide to build a pool or an addition on their property and road damage will be incurred as a result of that, but there's just a higher likelihood to it. The road is also being maintained by the developer. And yes, they are required to maintain it under the terms of the subdivision agreement. If something should happen and they fail to maintain it to the proper standards, and again, I am not a lawyer, so I'm just putting out my worst case scenarios for when I'm considering things like this. An accident should occur, and the municipality has given permission for this person to develop on this property. I think there's issues about liability with respect to that. Okay, so the road is owned by the municipality, which is not unique. We do have securities for it. The securities have been deposited by the developer, and the securities are drawn down throughout the construction process as development occurs. Now, typically, by the time the maintenance period is over or commences, securities are usually drawn down to between 15 and 20% of the total cost of works.
Just while you're thinking there,
Mhm.
I'll throw something else out for one of my questions. And I think it's very clear that this lot is not part of the subdivision. We've had that stated in your planning report and the submissions from our agent solicitor here this afternoon. And to my knowledge, there is no opportunity for it to ever become part of the subdivision. And hence, when I heard the comment that it be deemed to be part of the subdivision by means of a minor variance, I did not understand that and have no way of presently with the information I have of understanding that. It's not part of the subdivision. It can't be part of the subdivision. And by means of minor variance, it cannot become part of the subdivision. Am I correct in that thought?
You are correct in that thought. We can't make lands be part of a subdivision that haven't been included as part of the subdivision all along. It goes through an entire process, and this minor variance won't make it be part of the plan of subdivision. It doesn't work that way.
Could I perhaps provide a little bit of a correction because my submission on that point was perhaps a little bit unclear.
It certainly was to me, so I think you are certainly entitled to add some clarity to that comment.
So the purpose of that was not really to make it deemed as a legal part of the subdivision, but really to look at it from the perspective that because it's right beside the subdivision and on the same road, you can really treat it as a part of this subdivision development. I didn't mean to legally be deemed as part of it, and it was a bad choice of words on my part, so I apologize for that. I was just looking at it from the perspective of saying because a subdivision is allowed to develop in the same way, this lot owner here should be able to do the same. That was the only intention, and I apologize for creating that confusion.
Thank you. One of the other components that I had a question on was the use of the terminology year-round maintained road by our solicitor. And I believe the suggestion there was that it's maintained by the developer. But in fact, if we were to go to our own zoning document and look at the definition of year-round maintained road, it's going to be by the municipality or county or but rather than a private individual, or in this case, Mr. Dennis through the subdivision agreement. So I question the usage of the terminology year-round maintained road in that particular case as well.
Yes, through you, Chairman Jib. Section 11.1 of the official plan, I think that's the section that Mr. Yukaby was referring to. In the official plan, it does say an improved public road which is maintained year-round by the municipality or other public authority. So it does include that public component to it by the municipality. And that's to ensure that certain maintenance standards are adhered to because the municipality has certain maintenance standards. Now, the developer is required to maintain the subdivision road, Lees Court, in accordance with the subdivision agreement. But at this point in time, the municipality has no control over ensuring. We do have control through the subdivision agreement, but if something should happen with the maintenance of the road and it not be maintained properly, and there was an incident or something, we have no control over how it's being maintained.
We certainly don't have any good control. And in fact, I can speak to last winter when several of us did get calls from several of the property owners. And if my notes are correct, it was also the applicant in this particular case that reached out to me and talked about the maintenance on the road and some timing issues of when that was being done as well. I've interrupted your thought process, Jennifer, so I apologize for that.
That's okay.
And I'm sure we'll be coming back to our agent solicitor here in a moment and provide a follow-up opportunity there. Or would you like me to go to the agent solicitor?
You can go to the agent solicitor. I think I've addressed most of my points that I jotted down. The one important one that was that there were 4 existing developed lots. The lawyer did state that there is an easement to the subject property. There is an easement to the subject property. That easement has not ceased. It still exists. They can access their property. It just means that they have an easement, but they don't have frontage on a year-round municipally maintained road. But they do have access to their property. That is correct. I think that's all for now.
Okay, we'll come back to you, sir, and you had your hand up a moment ago, so feel free to continue.
No, and thank you. And the reason I raised that question of the easement was because the county, in doing its analysis and providing its comments, was left with the impression that our client did not have legal access to the road, or to their property. So that and one of the things that we needed to demonstrate was that we did have legal access. So I just wanted to make it clear that Ms. Lloyd does have legal access to her property and has a registered easement, which will ultimately have to be dealt with by the municipality when the road gets taken, because it can't be a public road with an easement over it. And so the last remaining point I'd like to say is that I wish I could share my screen, but the subdivision agreement is also very unique in these circumstances, because it does provide for the township to enforce the maintenance of this road, including the snow removal issue. And I also note that the schedule that is usually populated with lands to be conveyed to the municipality is left blank in that agreement, which is very telling. Really what's happening under the terms of this agreement is you've got a developer that is building works on behalf of the municipality on municipally owned lands. And so I think that is a very significant distinction, and it's a very significant legal distinction. And I don't want that to be lost on this committee as to one of the reasons why this application is indeed so unique. The municipality has the ability to enter into site plan agreements with our client and things like that if it so chooses, and that could be a condition of the approval as well. I don't want to belabor any further points. Those are really the submissions I'd like to make in response to those raised by staff right now.
Thank you. I should go to my fellow committee members here, which we have not at this point in time. So I will do so now. Do we have any questions or comments from committee members? Mark, please.
I'll go back to staff here. If staff would maybe answer this. There is a developer's agreement with the municipality. Within that agreement, it is just dealing with the road and the lots within the agreement. So there's nothing dealing with the lot that we're discussing here today.
Through you, Chairman Jib, that's correct. There's nothing in the agreement with respect to this lot.
So with us, and if we were to even look at this minor variance and pass this minor variance, would we not be breaking that developer's agreement within the municipality? Because we're putting onus on a developer to look after a road that for an individual on the road, which is not part of that agreement.
Through you, Chairman Jib, we would be adding additional traffic and impact on that road that has not been assumed by the municipality. That is correct.
Okay.
I'll
thank
just
you.
interject as we do have several here on Zoom with us. Let's make sure we get close to our microphones so everybody can hear adequately, if we could, please. Have follow-up questions, Mark?
No, I think that makes it clear for me. Thank you.
Thank you. Any further questions from committee members? Larry, please.
Yes, sir. Just a couple of questions. You indicated hardship. Does the applicant, do they have plans for a building? In other words, do they have an architect's plans or such to build a building on the property?
No plans exist yet because that analysis has to be done once the approval is provided, depending on which variances are provided. We can't get our plans drawn up until then.
Okay, and then secondly, is it the intent of the applicant to sell the property as soon as they got a variance?
I'm not able to answer that question. It was my understood that the intention was to build.
So the only hardship we have is that the applicant is sitting with property that they're paying taxes on. Is that correct? Or even
and unable to build a house on that property. It's for a 2-year period of time, and that in my respectful submission is hardship.
Okay, thank you.
Any further questions from committee members? Would staff like to have a summary here? Or I can go to the seeking a motion.
Certainly. I just wanted to mention one other thing with respect to site plan. The municipality no longer has the ability to require site plan on a lot for a single detached dwelling. Changes to the Planning Act were changed in the past couple of years. And now site plan approval for residential development can only take place when I believe it's 10 or more lots, or if it's in proximity to a wetland. So we used to be able to do site plan where we had concerns about a particular property for a single detached dwelling, but we can't do that anymore. So that the province closed that avenue to us with changes to the Planning Act. I agree that with the lawyer, I looked at the subdivision agreement myself, and that schedule in the agreement isn't populated that says lands to be conveyed to the municipality. However, those lands were under private ownership when the subdivision agreement was when the subdivision M plan was registered, and then the lands were conveyed to the municipality. So they were conveyed. They should have been included in that schedule in the subdivision agreement, but they were omitted. So
Thank you for that. Thank you for that clarity. Coming back to you, sir, would you like to say anything further, or want to be as fair as I can be here with time?
Yes, thank you. The lands in the subdivision were transferred to the township long ago. It didn't occur contemporaneously with this. I've done the title searches myself. The committee could get creative with this and impose a requirement to enter into a development or subdivision agreement as a condition of approval if it so chose to address the conditions. It need not be a site plan approval because it's a minor variance, and I would encourage the committee to consider that as a potential condition of approval. And other than that, I can't make my submissions more clear than I think I've tried to do already today.
Thank you. Well, we're at that point to make a decision. We certainly have tried to be open and fair here with an opportunity for all parties to provide information to us. It is our responsibility, of course, as Committee of Adjustment, to make a decision based on the application that's in front of us. And at that moment in time, I would ask for a motion, please. Mark, please.
I'll make the motion to deny the request for the minor variances.
Okay, motion to deny. Do we have a seconder to that motion? Seconder to the motion. John seconded the motion. Any further discussion or comments? All those in favor of the motion to deny? Carried. I believe it's appropriate that we identify reasons for our motion. And I'll come back to the mover, which was yourself, Mark, and ask for your reasons on the motion.
The reasons were identified within the planning document. I believe it's on page 8 of the planning report. And those were given by our planner here at the township. I believe there's 4 of them, and they're on page 8.
Thank you. Anything to be added by the seconder?
I think that pretty well covers it.
Thank you. Okay, I just want to make sure, because I've been trying to think of the technical component here. I did get a motion approved and seconded and carried.
And we've
Okay,
got the reasons.
thank you. I didn't want to leave this one loose in any direction. Okay, that completes that application. And I now need to get back to my agenda. And we have no other new business. So we can move on to adjournment. And prepared motion is that the Committee of Adjustment meeting held on January 9th, 2024 be adjourned at 3:01 p.m. I have a mover, please. Bruce, seconder. Mark, carried. All those in favor? Carried.